Hey everybody, how are you this evening? It's time for True Crime Wednesday. Thanks for joining us. I think we'll just give everybody a little time to catch up, and we'll chat about a few things. Don't forget, the book comes out September 24th. That little orange square there is my other book called The No Nonsense Guide to Divorce. And we are working hard on getting lined up book signings and readings and those sort of things. I'm super excited that I'm going to be at Powell's Books on September 26th. So just 2 days after the book hits the shelves, to do a reading there. For those of you who are familiar, Powell's Books is one of, if not the largest independent bookseller in the country. They're located in Portland, Oregon, and they do both used and new books. It is literally a 3 or 4 story building that is a city block sized building. That houses the original Powell's in downtown Portland. And it's an amazing place. In the late 80s and early 90s, when I was going to law school, my husband and I had date night on Friday nights, and it was always Mongolian barbecue and Powell's Books. So I'm really excited that that is going to be the first signing after the book comes out. I also have a book signing in Bend, Oregon, where I'm currently living in Redmond, Oregon, which is right next door to Bend. And so getting settled into the new house, I'm hoping to do a little painting, and that may help a little bit with the backdrop and the environment for our lives, hopefully. I have not forgotten that y'all have asked me about doing a show on domestic violence, and look for that to come up shortly. I kind of toyed with doing it this week. However, there have been a lot of developments. I'm not even sure if we're going to get to everything in our 2 hours today. So with that, I want to launch right in now that people are starting to join us, because we have a bunch to talk about. First of all, I wanted to go through some dates of some upcoming trials so that everybody gets an idea of what is going on. In August, so still to go in August, on the 16th, which is Friday, we have Shanna Gardner is having a discovery hearing. There's been a lot of discussion back and forth about whether or not there has been complete disclosure of discovery. And so there's a discovery hearing on the 16th. Then on the 26th through the 28th, we have Corey Richens finally having a preliminary hearing. Now, as you recall, preliminary hearings are generally done to determine whether or not there's probable cause to go forward with the case. The prosecution has the option of either presenting the facts to a grand jury or presenting it in a preliminary hearing. Different jurisdictions favor differently. The different jurisdictions have different opinions on whether they favor preliminary hearings versus grand juries. As we know, in Idaho, typically they favor preliminary hearings, but in the Daybell case, they presented information to a grand jury in order to keep some of the information confidential and not to further taint a trial jury pool. So in September, we have Donna Adelson coming up on the 17th of September. That is going to be a really interesting trial. There are motions happening in advance, and and we will cover them if they are live streamed. Then in October, y'all asked me about Lindsay Shiver. She is the woman from Georgia who is being held in the Bahamas on a murder for hire case. That case has been bumped to October, but there isn't a firm date yet. And unlike trials in the United States, their system's a little bit different. And so we don't have a date certain on that yet. Then, of course, in October also, we have from the 15th to the 31st, we have Richard Allen in the Delphi case. There are a lot of motions happening in that case continuing on. And we also have on October 2nd, we have motion hearings on Brian Walsh. Now, we're going to talk more about Brian Walsh because this is interesting. Brian Walsh is a case out of Massachusetts. And in fact, Trooper Proctor, who was such a problem in the Reed case and is currently under investigation by internal affairs because of his some issues in the Reed case, he is also the investigating officer on the Brian Walsh case. So it will be interesting to see that October 2nd case it has in part to do with Trooper Proctor. And then, of course, on the 7th of October, we also have Sarah Boone. Sarah Boone, we have lots to talk about with her today because she's acting as her own attorney. In December, we have James Craig on December 2nd. And then in January of 2025, we have Larry Millette. February of 25, we have Lori Vallow, her Arizona case. And in June of 25, we have the Koberger case. We're also being told that the Long Island serial killer Rex Heuermann case will likely go in the fall of 2025, but there are no firm dates on that yet. So those are some of the big cases that we have coming up. So I want to start very quickly by talking about YSL and Young Thug. That's a case out of Georgia where it is a RICO case. It does have to do with a murder. And you may recall this case has been going on for over 100 days. And in the midst of that case, the Judge Gallagher, who was the senior judge he was the presiding judge in that jurisdiction, was removed in a motion to recuse. He has been replaced by a very no-nonsense female judge whose name escapes me at this moment. One of the things that I have been encouraged about is the fact that she has really taken the prosecution to task over their lack of transparency, their clear lack of the discovery materials that they have turned over or not turned over. And she is definitely holding them accountable. There are still motions for mistrial on the table. To date, most of those have been denied, although there may still be some pending having to do with discovery issues. So those will be the judge will be deciding those as she determines whether or not the prosecution, after being ordered to fully turn over matters, has fully complied with their discovery obligations. It is somewhat outrageous to think that this trial has been going on for over 100 days, and there are still things that the prosecution has not turned over to the defense. The other thing that happened was that the prosecution's so-called star witness, who has turned out to be probably done more damage for their case than he has helped, his nickname is Woody. and he has been was on the stand at the time that this secret ex-parte incident happened, where the judge met with he and his attorney and the prosecutors. The judge then subsequently motion being filed to recuse him. And the judge didn't follow the rules when it came to those motions, because of something that was very clear in Georgia procedure, was that he was required to stop taking any testimony and, in fact, stop all proceedings until that motion was decided. He repeatedly denied it, rather than, as he was required, referring it to a different judge for a decision. So the current judge has gone back and said anything that occurred, any testimony that was taken after that motion was made, had to be stricken from the record. And that meant that, going clear back to June 12th, they had to redo all of Woody's testimony. And Copeland is his last name. And so he is now back on the stand, continuing to give the prosecution absolute fits about whether or not he will testify. The judge granted their motion to be allowed to treat him as a hostile witness, which means they can ask leading questions and they can attempt to impeach him. But essentially what he has said is, I always lie to the police. So I always lie. And so I don't remember what I said to the police several years ago, but I always lie. And I will lie in order to take the police focus off of me and put it on someone else. So they're not getting a tremendous boost to their case because he is not at all a credible witness. So that will continue to follow that. And another little interesting thing that happened was that the attorney, his name is Melnick, who has been Woody's attorney, was suspended from the bar for 6 months in an unrelated issue having to do with child support and custody issue. And the state bar and the Supreme Court determined that an appropriate sanction for that violation was for him to be suspended from practice for 6 months. So the judge was in the process of appointing Woody an attorney to represent him as he continues his testimony under the immunity order with the prosecution. So now, the next thing I want to talk about, the next case I want to talk about is Karen Reed. Now, yes, we know the Reed case, the judge found that the jury was hung up, that the jury was hung, declared a mistrial, and then it became clear that the jury did not understand the jury verdict form, and the jury came forward both to the defense and the prosecution and revealed that they had found not guilty verdicts unanimously on 2 of the 3 counts, and it was only the second count, which had to do with lesser included offenses of manslaughter, that they were hung on. So the prosecution, the defense filed motions to dismiss the charges in alternative to at least dismiss the 2 that the jury found that they were unanimous on. They had a hearing that was that the judge heard argument on whether or not to dismiss those charges. The prosecution says that they intend to retry the case. I believe it's set for January or early February next year. And the Judge Canoni, took it under advisement and has not made a ruling on it yet. But as you all know, the Canton Police Department, Canton is a suburb of Boston, and there have been widespread allegations of corruption among the Canton Police Department and the state police department as well. So one of the problems, there are a number of other related cases. Now, you might remember that Trooper Michael Proctor was the lead investigator on the Reed case. He is a state trooper. He is an officer in the state police, the Massachusetts State Police. And it's not at all uncommon, particularly when there is another law enforcement organization involved, for the state police to get involved. So Trooper Proctor was responsible for this investigation. For anybody who watched the trial, you know that he made very disparaging remarks about Karen Reed. There's a lot of question about whether or not he manipulated physical evidence. There's a lot of question about whether or not he manipulated the videos that were taken inside the Canton Police Department, outside of John O'Keefe's home, and a number of other videos. So there's a lot of suspicion surrounding Trooper Proctor. Following his very poor performance at the Reed trial, he was placed on administrative leave, first of all with pay, but when the furor erupted over that, he was placed on administrative leave without pay. And he is currently under investigation by internal affairs from the state police, the Massachusetts State Police. But interestingly enough, he is the lead prosecutor or the lead investigator in a couple of other high visibility cases. And now we are left with what happens with Trooper Proctor. So he also was the lead investigator in the Brian Walsh case, in the murder. Brian Walsh is accused of murdering his wife, Anna Walsh. Although there was a great deal of physical evidence found that would indicate that he was responsible for her murder, her body has never been found. So here's the issue. Trooper Proctor's malfeasance in the Reed case could jeopardize every other case that he's been involved in, because the defense in every other case that he's been involved in is going to use it to call into question every investigation he's touched. They're going to call into question his ethics. They're going to call into question his intentions, and they're going to challenge, in addition, they're going to challenge every conviction where Trooper Proctor was the investigating officer. So there is an avalanche of new actions that are going to come out of whatever comes out of the internal investigation for Trooper Proctor. I think it would be incredibly surprising to just for them to come back and not discharge him, not terminate him as an employee, and to find that there was misconduct. So that being the case, it opens up just a Pandora's box of litigation having to do with Trooper Proctor's investigation. Now, when I was still practicing here in Oregon, we had a situation where we had a crime lab employee who it was discovered was falsifying crime lab reports, potentially was lifting drugs out of the crime lab storeroom, and some other misconduct. And it led to hundreds of motions being filed, asking for review or new trials in cases where convictions were obtained based on that crime lab technician's reports. And that was really a small percentage of what may have been Trooper Proctor's career of investigations. So I think we are about to see a real avalanche of motions being filed on the behalf of defendants whose cases were investigated by Trooper Proctor. There's also an interesting sort of overlap, and that has to do with Sarah Birchmore. So Sarah Birchmore was a young woman who was an explorer scout for the nearby Stoughton PD. And I hope I'm saying that right. Maybe y'all pronounce it Stanton. I'm not sure. It's Stoughten. Maybe Stanton. So there was an officer there. His name is Matthew Farrell. Farnell, Farnell. He started supervising this young woman at age 15 when she was an explorer scout. She was groomed and ended up entering into a sexual relationship with Matthew Farnell, as well as 2 or 3 other officers within the Stanton Police Department. She was 23, had an ongoing relationship with Matthew Farnell, and was pregnant and had just told him that she was pregnant. When she was found dead in her apartment and the medical examiner ruled her death a suicide. Further investigation, now her family filed a wrongful death suit. So it's a civil suit, not a criminal suit. And as a result, they had an independent medical examination done, and that medical examiner was very clear that that medical examiner believed that she was the victim of a homicide that was made to look like a suicide. So here's the interesting thing, because it was an internal issue within the Stanton Police Department, and they are a neighboring police department to Canton. Both Canton Police Department and Proctor, Michael Proctor as Massachusetts State Police, were involved in the investigation into the misconduct having to do with Sarah Birchmore. So yet again, we have these layers of misconduct going on. And it is very clear that there is a level of systemic corruption in the Canton, Stanton, and other police departments in suburban Boston. I think there's been a long history of the potential for corruption in Boston and its suburban area, where law enforcement has a tremendous amount of power and have for generations. And membership in law enforcement is very generational. Families create law enforcement dynasties back there. So that one is going to be one to watch. I know that there are many people who hope that the investigation into Sarah Birchmore's death is going to be reopened, and are hopeful that there may be criminal charges coming for the police officers who exploited her, mistreated her, and potentially caused her death. So moving on, I want to talk a little bit about Lindsay Shiver. Now, for those of you who who have been watching me for a while, you know, I have a family connection in the Bahamas. My husband's sister has lived most of her adult life in the Bahamas. She was married to a Bahamian doctor. And this is a really interesting case to me because I know a little bit about the Bahamas and their legal system. Now, their legal system is based on British common law because they originally were a British colony. So their legal system differs quite a bit from the United States. British and US, although both sort of based on British common law, really have some substantial divergences. But the other thing that is fascinating to me is that in the Bahamas, in the country of the Bahamas, there is a single prison. And that prison has universally and over the years been designated as one of the top 10 worst prisons in the world. We're talking worse than South American prisons, worse than many, many prisons. And it is, the conditions there are horrendous. You are essentially in a cell most of the hours of the day. There are open bars on the windows, but there's no window coverings. So you're constantly inundated by insects. There's no running water. So your facility is a bucket in the corner. It is vermin infested, and it's very difficult. If you do not have the wherewithal to bribe the guards to allow your family to provide you with food and sort of additional comforts, then you are in very difficult straits. And Lindsay Shiver was a woman from Georgia. She was married to a pretty wealthy guy who was involved in, had an extremely wealthy family. He was involved in insurance, I believe. And his family were wealthy enough that they had a private jet that they would fly back and forth to their vacation home out in the Out Islands in the Bahamas. She got involved with a bartender at the bar near the family's vacation home. And it is alleged that she and the boyfriend solicited a third party to murder her husband. She was in the middle of a very contentious divorce from him. He had discovered the affair. They were arguing over child custody and access to the children. And she was extremely frustrated by the fact that he was cutting her off from contact with his family, contact with the children. And it was a really highly conflicted situation when it is alleged that she attempted to have her husband murdered in order to dispense with the conflict. We were told that now, once again, the Bahamas has a very different system, and they're not necessarily releasing information the same way we would expect to have released in an American courtroom. So they have not released a specific date, but it appears that her court date has been moved to October of this year. But we don't have a specific date. She is out on bail and on an ankle monitor. She was allowed to leave the Bahamas and go back to the US while still on an ankle monitor to visit her children and her family over the Christmas holidays last year in 2023. But she was required to return, and she is currently living in the Bahamas out on bail and awaiting trial. So that one is going to be very interesting, because if she is convicted, she will end up in Fox Hill, and under conditions that are really horrendous. And there is very little that the American government can do to try and mitigate that incarceration for her. So it's not as if they can ask her to be transferred to the United States to serve her sentence. So we'll be watching to see how that develops. There is a trial that's going on right now, actually started today. We had opening statements and they began taking testimony, and that is the case of Robert Hellis. This case has some interesting ramifications, if I must say. This is a case where 69-year-old Jeff German, it is spelled like German, but pronounced German. He was an investigative reporter, and he was investigating reports of misconduct or malfeasance on the part of the Clark County public administrator. Now, that is the county that Las Vegas is in. And the public administrator is responsible for dealing with the estates of people who die intestate, who die without wills. And so the public administrator's job then is to resolve those estate issues. So Robert Hellis was a lawyer. He went to law school. He opened a probate practice. And after about 3 years, he ran for office to become the administrator. Now, there's a couple of different stories, and it's interesting because I think both of them could be true. But right now, the defense is and the prosecution are painting two different stories. And it really is going to be up to the jury to sort through and to decide what's true, what's not, and whether one set of facts sort of excludes another. So what we heard today was the fact that Hellis, the defendant, alleges that he took over the office and that it was a very cozy arrangement where the people who were working within the office were often racking up 20, 30, 40 hours of overtime a week. A lot of these people were literally doubling their annual salaries with overtime. He believed that it was excessive, and he cut back the use of overtime in the office, and that created a lot of hard feelings. That he also believed that he had uncovered a scheme where there was a third party, a real estate interest, who would come in, would buy these the homes of people who had died without a will, and buy them for pennies on the dollar, and then turn around and sell them at tremendous profits. And he believed that he had uncovered this fraud. So he began reporting that fraud to local law enforcement. But during that time, his contention is that it was because he cut them all off from their use of excessive overtime. The staff in his office began talking to Jeff German about the hostile work environment that had been created since Hellis took over as the elected official. So German began investigating and talking to all the staff members, talking to other people, and he believed that he had uncovered what turned out to be a hostile work environment. Additionally, the people in the office alleged that he was having an extramarital affair on company time with one of the members of the staff, that someone who worked for him. So what happened was Gurman published a series of 4 articles having to do with the controversy that was going on in the public administrator's office. And as a result, he was Hellis was being sorry, we still have a fair amount of smoke here from the wildfires. Hellis was being challenged in his bid for re-election. So one morning, neighbors in Gurman's neighborhood, where he had lived for 20 plus years and knew all the neighbors, noticed that his garage door was open, which was very unusual for him to leave his garage door open. And the garage door was open overnight, which was very unusual. They attempted to contact him, to text him, and to call him, no response. So the next day, one of the neighbors went over to check on him and found him, his body outside a side door in his home, having been stabbed to death. And as law enforcement began to investigate the case, they got, of course, the ubiquitous ring cameras and surveillance videos, and were quickly able to determine that a figure, a person who they were really unable to identify, walked down the street from someplace up the block in a bright orange shirt, typical of people in the area, especially people who do yard work. It's very hot there. They often wear sun protection shirts, and they often wear them in very bright colors. He was also wearing a large, oversized straw hat, which is also very common for people who work outdoors in Nevada, Arizona, those areas during the heat of the day. So they watched this person in black baggy pants, this bright orange long-sleeved sun shirt, and this very oversized straw hat walk down the sidewalk and walk along the side of hello, sorry, we had a little glitch there. We may have some glitches tonight because we are expecting some thunderstorms. So bear with me if we have some glitches, some internet glitches. So the Ring doorbell catches Mr. Gurman pull into his garage and then come out and walk along the side of his house. So obviously the person who was waiting for him knew that that was his habit, was to enter his house by a side door. There you can see in the Ring doorbell, there's some bushes in front. You can see some movement behind the bushes, and then that person still dressed in the orange shirt and the big hat that covers the face, come back out, walk down the sidewalk, and then they were able to find other surveillance cameras and Ring doorbells that followed him up the street until he got into a maroon SUV. So they then in the autopsy, they took scrapings from underneath Mr. Gurman's fingernails and discovered Mr. Hellis's DNA, the defendant's DNA, under his fingernails. So armed with that, they went back and served a search warrant on his home discovered that his wife drove a maroon SUV of the same kind that they had seen in the surveillance videos. And they were able to find a pair of Nike shoes that had been cut up, pieces had been cut out of them, as well as a straw hat that had been cut up into pieces, apparently to be disposed of. So those things then gave them circumstantial evidence that Mr. Hellis had been responsible for the death of Mr. Gurman. So the defense is claiming that Mr. Gurman had prior death threats because he was an investigative journalist, and he had investigated other crimes or other stories that could have given rise to threats for his safety. And in fact, that there were threats that had been made to him about other stories that he had written. And of course, the prosecution says that this was strictly a way for Mr. Hellis to get Mr. Gurman to stop writing and revealing all of this misconduct that was going on in the administrator's office. So Mr. Hellis was suspended from the practice of law. He lost his reelection bid and then was arrested for the murder of Mr. Gurman. That trial is expected to go on for 2 weeks. I did think that the first few witnesses went pretty quickly, and so it will be interesting to see whether that they managed to finish quicker than is expected. They did seat a jury quicker than I think they expected to. So now I want to talk about Larry Millett, because I was asked to look into this case. This is a case, and I will continue to follow it. It originally was set for this month. It has now been moved until January of 2025. This is a case out of California, and it has to do with Larry Millett's wife, Maya, who has been missing since January of 2021, and her body has not been located. We have a number of cases where there's no body. Of course, we have Suzanne Morphew, whose remains were finally found recently. And interestingly enough, we have yet to see charges against Barry Morphew. He originally that's a case out of Colorado. He was originally charged, and the charges had to be dismissed due to some pretty substantial misconduct on the part of the prosecution. So we will see whether that, in that case, we are whether there is whether that case actually goes to trial and what sort of evidence they have. Then, of course, we have Anna Walsh, whose body was never recovered as well in the Brian Welsh case. And the next thing I want to talk about is Shanna Gardner. Now, Shanna Gardner, this is a murder for hire case. This is the case with Jared Bridegan. He was Shanna Gardner's ex-husband, and they had children together. He had remarried and had young children with his second wife, and he was a Microsoft executive. Shanna Gardner is being represented by Jose Baez, who also represented Casey Anthony. So he's interesting to watch. And I'm certain that case will be live streamed. There is a hearing on Friday on discovery violations on that case. And so I'll be watching that, and we'll be following that. I'm sure those will be streamed. There's also a question of spousal privilege, because the person who is alleged to have been responsible for Jared Bridegan's murder is Shanna Gardner's current husband. But Jose Baez is alleging some very serious Brady violations, and the prosecution says that Baez is just engaging in theatrics. There is no trial date yet. We're hopeful that perhaps a trial date can be set on Friday when they hear those motions. So we'll be keeping an eye on that. Holy cow. You also asked me about James Craig. That is a case out of Colorado and is the dentist who is accused of poisoning his wife by using cyanide and eye drops to kill her. That case was scheduled to start trial within the next few weeks. And that case has been moved until December 2nd. So I'll continue to keep that one on my list of things to follow. And in Utah, we had Corey Richens. She is the Utah mom who is accused of having spiked her husband's Moscow Mule with fentanyl in an attempt to, and she actually made 2 attempts on his life. The first one, she gave him a sandwich on Valentine's Day. It made him very ill, and he believed that she was trying to poison him. She then went back to the person who was the source of the fentanyl and asked for stronger fentanyl, and he then died shortly after. It's come to light that she was having an extramarital affair and that she also was deeply in debt. She was involved in buying, fixing up, and flipping houses. She was deeply in debt and he had foiled her attempt to buy yet another McMansion that she was going to attempt to flip. So, that one is set for preliminary hearing this month, the 26th through the 28th, and I'm certain that a lot of people are going to be very interested in that one as well. Out of Florida, we have another case that's going on right now. The defendant's name is Susan Lawrence, Lorincz, and this stemmed from a neighbor dispute. She killed Ike, Ajike, Owens, because she was upset that Owens' 4 children were playing in a vacant lot next to Susan Lawrence's home. So she complained that she worked from home, that the children were too noisy, that they were out in this vacant field. Although the local residents claim that they were told by the person who owned the vacant lot that the children were welcome to play there. So it was an ongoing dispute. She harassed the children. She called them names. She was constantly calling law enforcement. She was what folks in the common parlance call a Karen. And she was harassing and really very inappropriate with these young children who were playing outside. So it finally came to a head when one of the little boys, one of Owen's 4 little boys, she was a single mom, left his tablet over in the field while they were playing games. He went back to get it and discovered that the woman, Lawrence, had it. And when he asked for it back, she threw it at him and hit him with it. And he went back and told his mom what had happened. And she went over to confront Lawrence over the fact that she had thrown things at the little boy. There was a pair of roller skates that were also left on the property, and she threw those at him as well. And she went over, Owens went over to confront Lawrence. And when she got to the front door with one of her young children kind of standing behind her, Lawrence fired a gun through the door and hit Owens. And she was declared dead on the scene. And the video is just heart-wrenching. It is absolutely beyond belief. It's shocking and absolutely heartbreaking. These 4 young children saw their mother shot, saw emergency crews working to save their mother, and then are told by what appears to be a family member, but could be a neighbor, that their mother didn't survive. So it's an awful case, and it is going on right now in Florida. Speaking of Florida, of course, we have Donna Adelson, who a couple of YouTube creators call Grandma Gotti, who is going to be starting her trial on the 17th of September. And boy, are we going to be watching those. Her attorney, Rashbaum, just recently filed some pre-trial motions. One of the motions he filed was that he wants the trial moved to a smaller courtroom. Charlie Adelson's trial took place in the largest courtroom, and he is asking for a smaller courtroom to limit the number of people from the public that are available, that would be allowed to get into the courtroom and watch the trial. They claim that some of the people who were in the gallery were expressing opinions about the testimony, rolling their eyes, and sort of communicating with the jury. The other thing that he has asked for is that they want to exclude the wiretaps. Now, he made similar motions in Charlie Adelson's case, and they were denied. He acknowledged that in his motion, and I don't believe that those are going to be granted. So, very interesting how this case moves forward. For those of you who may not be aware, although I can't imagine anyone is, of the Adelson case, Professor Dan Markell in, I believe, 2016 was murdered in a murder for hire scheme. It was put into place by the Adelson family over a custody dispute, and Donna Adelson wanting her daughter Wendy, who was Professor Dan Markell's ex-wife, to be able to move from Tallahassee, Florida, up in the north, up in sort of the northern part of Florida, down to South Miami Beach, because they wanted the grandchildren closer to them. Professor Adelson was a very engaged father. They shared custody pretty much 50-50 of their 2 young children, and he opposed his ex-wife being able to move with the children. After the judge ruled in his favor that the boys could not be moved away from Professor Adelson, then this scheme was put in place, and 2 gunmen who were hired by Charlie Adelson. Charlie Adelson is Donna Adelson's son, Wendy's brother. His girlfriend, Catherine Magbanowa, was able to act as a go-between and find 2 men who were willing to drive from Miami to Tallahassee and murder Professor Dan Markell. So that case has been going on and on. What has happened is the prosecution have very systematically gone after, starting with the lowest hanging fruit, the gunman, Katie Magbanowa, then Charlie Adelson, now Donna Adelson. Donna was arrested on the jetway as she was attempting to board a flight for Vietnam, which does not have an extradition treaty with the United States, just days after Charlie Adelson, her son, was found guilty and sentenced to life in prison. So The prosecution claims that that is clear consciousness of guilt. Her attorney disputes that. Donna and Harvey Adelson were very wealthy people. They lived in a penthouse of a high-rise apartment building in South Beach, Miami. He was a dentist, had several dental locations, and they had a lot of money and a lot of power, I think, in the case. At one point, they offered Professor Markell $1 million if he would leave his tenured position at the University of Florida, or FSU, Florida State University, and move to Miami, or allow the boys to move. Sorry. So Donna Adelson will start her trial in mid-September, and I'm sure that that is going to be one that's going to be very closely watched. Also out of Florida, we have Sarah Boone. And for those of you who know, Sarah Boone is accused of having zipped her boyfriend, excuse me here. I need to reach for the Kleenexes. Sarah Boone is accused of having, in a game of hide and seek, during a drunken game of hide and seek, having zipped her then boyfriend into a suitcase and then passed out and forgot he was there. He suffocated in the suitcase. She claims that it was an accident, that it simply was a terrible set of circumstances, and that there was no intention. Unfortunately, when they downloaded her telephone, there were videos of her that she recorded taunting him while he was in the suitcase, telling her that he couldn't breathe. Sarah Boone is clearly mentally ill, but not mentally incompetent. And she has been through 8 attorneys. Now, a couple of those attorneys withdrew for reason of having a conflict. One changed jobs, I think maybe even got appointed to the bench. So not every one of those attorneys was her fault that the attorney got off her case. But at least 6 of them were. Her inability to get along with people and her inability to communicate effectively with her attorneys. Her final attorney, an attorney who is, whose name is Patricia, I think, Cashman, a very experienced lawyer, very experienced criminal defense attorney and public defender, who spent 20 hours with Sarah Boone trying to go over her case, and Sarah Boone could not get along with her. So my observation is that I have represented a few people like Sarah Boone over the years. And Sarah Boone is one of these people who is incredibly self-absorbed, very narcissistic, and who believes that if you don't agree with her, you didn't hear her. And so she believes that her attorneys are not fighting for her, not prosecuting her case the way that she wants them to, because they're in the position of telling her this is not a winning argument and there is not evidence to support what it is that you claim. And I cannot perpetrate a fraud on the court. I can't go before the judge and say, Judge, this is our defense, when there's no evidence to support it. And in fact, it could be me being seen as suborning perjury. After the 8th attorney was allowed to withdraw, the judge said to Sarah, you must represent yourself. You have effectively waived your right to court-appointed counsel by your behavior, and you have forfeited the right to have court-appointed counsel. The Sixth Amendment right to court-appointed counsel is not limitless. And in this particular case, there was support within Florida case law for the fact that she is, the court was within his right to require her to represent herself. She's very unhappy about that. She doesn't really, she's said over and over again, I don't want to represent myself. I'm unprepared. I'm underqualified. I'm not qualified. And the judge has said, you were cautioned that if you continued to undermine your court-appointed counsel, that you would be required to represent yourself. And it is a case of F around and find out. So she has filed a number of more motions. Now, Sarah Boone is not stupid. She's a fairly bright woman, and she has been able to formulate some motions and has filed some motions with the court. There is no question that she is at a distinct disadvantage. Her only way to communicate with the court in this day and age where everything is filed electronically, everything is served electronically, in this day and age, her only way to communicate with the court and with witnesses and with her investigator is either on a monitored phone line or by mail. So anytime the court sends her a notice, it has to go through the mail. It has to go through the jail's mail system, which is somewhat cumbersome, and has to be delivered to her. And that can take up to a week. Conversely, when she files something with the court, she has to do it through the mail system. So she turns her mail over to a mail drop within the jail. The jail then goes through their equally cumbersome system to get outgoing mail out, and then the mail is put in the postal service. So it often takes days for her to file something with the court, and it often takes days for her to get notice that the other side has filed something. So she has filed several motions. One of the motions which she filed was that she not wear handcuffs when she is in court. I think this is a reasonable request because she's trying to take notes. She's got her hands cuffed together to belly chains. So the judge agreed that if she would wear a taser called a stun cuff, that he would allow her to be hands-free in the courtroom. She has agreed to that. It is a device that fits on her calf and that can be activated essentially as a taser that can be activated if she acts out in court. So there was some discussion today about what she was going to wear during her trial, whether or not she wanted to wear a skirt or slacks. She said she wanted to wear a skirt. So then the issue is, would a skirt cover up that device? Because they're required when she's in front of a jury for it not to be evident that she is in restraints. So the judge agreed that she could that the jail could use that stun cuff in lieu of having her belly chained, ankle shackled, or handcuffed. The public defender has been working with the court and the jail to provide her with clothing during her trial. So most public defenders' offices maintain some sort of a closet of clothing for in-custody defendants to wear when they are in court. We saw it in the Lori Vallow case. We saw some really interesting choices, including zebra striped leggings and camo leggings and those sorts of things. Sarah Boone will be provided those unless there is, will be provided with whatever is available in her size in the public defender's closet, unless somebody from the outside provides her with clothing to wear to court. That is a possibility. The judge did say that, and the jail agreed that that was a possibility if someone provided that clothing. Sarah Boone also filed motions asking for some special treatment within the jail. Now, the jail is not required, and in some cases is precluded from doing some of the things that she asked for because of security considerations. So she is currently being housed in an open bay, meaning that it's like a military dormitory where there's a bed every so far, and she has limited access to a security box and a security bag. So there was quite a bit of discussion today about what that looks like. She has asked for hard copies of her discovery. All of her discovery was loaded onto thumb drives, and she was to be given access to the thumb drives as well as to a laptop in order to be able to access all of that discovery. The problem for her was that she wasn't able to sort any of that information or make notes on it or any of those things. And it was difficult and cumbersome for her. So she asked for hard copies of all of that discovery. The court ordered that it be provided to her. So it was provided in 2 cardboard banker's boxes. Now, she really has nowhere to secure that in this open bay facility. So it's just kind of sitting there next to her bunk. In the process of this hearing, where the person who supervises the jail was also appeared remotely with their attorney to address for the court some of Sarah Boone's requests. She asked for more access, longer access to her, to the laptop and to the discovery that's on the thumb drives. She asked to be able to use the classroom when it is not in use by other inmates. She asked for access to the internet as well as access to a telephone where she could make phone calls that were not monitored and were not subject to being made collect calls. And she asked for access to word processing programs so that she could write her motions on laptop rather than handwriting them. So the judge pretty much denied all of those motions. The jail said that they would allow her an additional 2 hours every day after the evening meal and before head count and lights out to use the laptop. But they were not going to give her workspace within the jail to do that. The jail did offer that they could move her into a housing unit where she would have her own private cell, and then she could access all of that information in whatever way she wanted. That would require that she be in a cell rather than in an open bay, and that she not have the same sort of freedom and social interaction that she currently has. To this point, she has declined that. She doesn't want to be in a lockdown cell. She also made an oral motion, and I'll get to that in a minute. So she asked for phone access and internet. She was offered a private cell, but doesn't really want to be on lockdown. She said, now at the last hearing, the judge approved $10,000 in fees for an investigator. That investigator is pretty much being made available to her almost exclusively. And he has been working with her and was working with her on making sure that she had access to all the discovery materials. But she needs to use, the court really said that she needs to use her investigator, and her investigator needs to be the one who is contacting witnesses, interviewing witnesses, setting up those sorts of things. At the last hearing, she made an oral motion to close the hearing that was scheduled for September 3rd. That was an evidence review hearing. So what usually happens is an appointed attorney and their investigator usually go to the police department, to their evidence locker, and review the evidence that is available in the case. That means if there's physical evidence, the technician that is there in the evidence room opens the bags, makes the evidence, puts the evidence out on a table where it can be photographed and examined, and then it's secured back into the evidence envelopes, resealed, initialed, and there is a running tally of all of those things, what's opened, what's viewed, all of those things. But because Sarah Boone doesn't have counsel, the judge said, I will hold a hearing. We will bring all the evidence to the courthouse, and you will have the opportunity in an open hearing to review all of that evidence. She did not want that hearing to be live streamed. And so the judge reviewed the case law and heard from the lawyers representing a couple of the media outlets and said, no, there is no basis for me to close that hearing. However, the prosecution has arranged with the jail to have Sarah transported to the evidence locker, to the evidence, and to be able to view the evidence in that environment the same way that a lawyer would have, along with her investigator. So they decided that September 3rd hearing didn't need to happen because they've made other arrangements for her to be able to physically view the evidence. So that hearing really kind of became moot at that point. So the jail supervisor did come up with the jail supervisor expressed a couple of concerns. Sarah Boone wanted to be able to keep the thumb drives in her secured property so that she could be assured that they weren't being tampered with. The judge had set up a protocol where she would check them out and then check them back in to the security desk. She didn't want to do that because she wanted assurance that they weren't going to be tampered with. Now, she also has hard copies of all of this discovery, so it would be pretty clear if they were being tampered with. But the jail supervisor pointed out that thumb drives contain metal and that they are things that cannot be introduced into the jail. And so while she is allowed to use them and to use the laptop while she is doing her trial preparation, she is not allowed to keep them, and because they could be used to make other things out of metal. So she is not allowed to do that. The supervisor also pointed out that there is a volume of paper and cardboard boxes that are a fire hazard, and that she is specifically required to limit fire hazards. Now, remember, this is a big, big prison. The supervisor said she is in charge of 400 inmates, and that's just the female population. So they did come up with a workaround and a solution. Sarah Boone has been given these sort of large fire retardant securable bags, and so the jail has agreed to provide her with 2 extra of those bags, as well as manila envelopes that don't have clasps or strings or any of those things on them, so that she can sort and categorize these files before they go into this big bag that has no dividers, or, it's just a big like canvas bag. So they are attempting where they can to assist her. But as the jail's attorney pointed out, they are not really required to give her anything but a pencil and paper. And she is, and access to her discovery. So there was some ongoing conversation about whether or not she could purge some of the things that she already has, whether they could go into her property locker. And so there were some discussions about the logistics of that. But essentially, the court denied most of Sarah Boone's motions. So, and the judge repeatedly explained that this really was of her own making by alienating several of her attorneys. So there's a case going on now. It is a case of Crystal Rogers, and it is another missing body case, no body murder. Stephen Lawson is on trial, and I'm going to try to tune in on that one because apparently he just fired his lawyer today. This is a case where Crystal Rogers went missing. Stephen Lawson was her boyfriend's significant other. Her car was later located. Her father organized search parties to try and look for her body, which has never been found. And prior to him leaving to organize a search of a specific area, he was gunned down. So it's a really convoluted but interesting case, and I am going to continue to try and get updated on that. But there are several trials and a lot of hearings going on this week. I am specifically following the Hellis case as well as the Lawrence case, and I will try and get up to speed on Crystal Rogers as well. There were a couple of minor developments in Vallow and Daybell, so I wanted to bring you up to speed on that. Lori, as you remember, Lori Vallow is in Arizona awaiting trial on allegations having to do with Charles Vallow's murder, as well as the attempted murder of Brandon Boudreaux. She has repeatedly refused to waive her right to a speedy trial. And her attorneys, court-appointed attorneys, came to court and filed motions explaining to the judge at the last status hearing that there were 8,000 pages of discovery that needed to be reviewed, that he had been through about 600, but there was no way he was going to be prepared to start trial in early September. And the judge agreed to a continuance until February of 2025 over Lori's objection. She applied, they filed a motion for her to be able to appear in civilian clothes at all pretrial hearings. And the judge denied that motion, that she would only be allowed to wear civilian clothes, street clothes during jury selection and trial. The next hearing is a case management hearing that is coming up on September 6th. And so we'll be continuing to watch that. Chad Daybell recently had a hearing where his current attorneys, who are his appellate attorneys, were asking for more time to file their initial briefs with the appellate court. They only just got the transcripts from Chad's trial. It takes months. I'm surprised they're ready already. It takes months to create those. The appointed counsel said that the transcript alone of the trial is 6,000 pages. They said they also need to review the transcript from Lori's case because there were similar witnesses. Many of the same witnesses appeared in Lori's trial. And they are putting together a claim for ineffective assistance of counsel. Now, remember, ineffective assistance of counsel is a two-step question. First, they must prove that the counsel was ineffective, okay? So I think this is going to be a little bit of a hard battle because there were different junctures at which Chad Daybell could have asked for court-appointed counsel and did not, and continued to say that he didn't want John Pryor to leave his case on more than one occasion. And it's very clear, John Pryor was very clear to protect the record and himself on the issue of mitigation, because the attorneys brought up the fact that they did not believe that there had been adequate mitigation done. Now, if you recall, after the guilty verdict came and they began the mitigation phase, Chad Daybell specifically said, I don't want to put on mitigation evidence. There was a lengthy in-camera or in-chambers hearing that happened outside the jury as well as outside the public, at which John Pryor put on his evidence and made his offer of proof, his proffer, and asked the judge to inquire to Chad about whether or not this was his decision. So I think that's going to be a tough one. So the first prong is you have to prove that your counsel was ineffective. And second, you have to prove that but for your counsel's poor performance, the outcome would have been different. That is going to be the very tough prong to prove. So, because Lori did have public defenders, she did have the opportunity for a defense team, and she was found guilty on similar evidence. So I think ineffective assistance of counsel is going to be a tough climb. Yes, I think that John Pryor did the best he could with what was before him. Yes, I think that he could have done a better job. Yes, I think there was other information that could have been presented. But the question is, would the outcome have been different had he had a different lawyer or his lawyer been effective? So I think that's always a tough mountain to climb, and I kind of doubt that goes anywhere. So we'll wait to see. His counsel was given extra time to file their appellate briefs, and so we'll be looking forward to moving forward with that. There is also, I want to say while we're in Idaho, I wanted to bring this case up. It is the case of Skylar Mead. This case happened recently, not long before I moved out of Idaho. An inmate in the jail in Ada County. No, actually, I think he was a prison inmate at that point. Inflicted injuries on himself that required that he be taken to the hospital. He was taken to the hospital in Boise, where there was an accomplice standing by to help him escape from custody while he was in the hospital. It's interesting because my mom, who you all know, was living nearby me in assisted living in Boise, and is now living nearby me in Redmond, Oregon. She used to go to downtown Boise to receive treatment at a Boise clinic. And just about every time I took her there were inmates coming in and out, dressed in prison garb, in handcuffs. But it's interesting that it definitely is a less secure environment. So he goes to the emergency room with these self-inflicted injuries. And while he is there, his accomplice shoots the three guards that are there to accompany him to the appointment. And one of them, he shoots two of the three guards. One of them ends up in ICU. They all survive, but with various injuries. And it is suspected that he and his accomplice are being investigated for two homicides that happened in northern Idaho that they have not been charged with. So at this point, he has been charged with escape. His accomplice is being charged with attempted murder as well as escape. And so that one is going to be an interesting one to continue to watch. What brought it to mind is the fact that Ann Taylor, who is Brian Kohberger's appointed public defender, has also been appointed to represent Skylar Mead. Unfortunately, like many states, Idaho is not exclusive in this way in any way. Many states, there is a real shortage of public defenders. A lot of states, my home state of Oregon included, have given short shrift to public defense funding over time. And really the states have come to the point where it's become a crisis. They can no longer attract attorneys who are willing to take the crippling caseloads and the ridiculously low hourly rate pay in order to take the cases. And so there is a shortage of qualified public defenders. Ann Taylor is one of probably 15 lawyers in the state of Idaho that is qualified, death penalty qualified, as lead counsel. So that is going to be a continuing issue for a lot of these high visibility cases. So Ann Taylor continues on as Brian Kohberger's attorney. He is the guy accused of murdering 4 students at the University of Idaho in Moscow. Kohberger, they are still wrangling over change of venue motions, over discovery. I would say that the prosecutor in that case, I find him to be sort of a dismissive old white man who is not going to give an inch more than he absolutely has to, and has been in a lot of cases hiding the ball. And Ann Taylor is very on top of it, very experienced and very well prepared at all times. So that one is a really worthy matchup. Ann Taylor's team has filed a motion to move the case out of Moscow and to Ada County. We saw the Vallow-Daybell cases move there. Ada County did an excellent job of managing high visibility cases. And based on the surveying that Ann Taylor's team had done, I would be very surprised to learn that the court was not going to move the case. Of course, the prosecutor wants it to stay in their backyard. So no decision has been made. In fact, there are additional hearings coming up on that, I believe. Then we had some kind of unusual information having to do with Alec Murdaugh out of South Carolina. As you recall, Alec Murdaugh was found guilty of murdering his wife and his son. He is a disgraced South Carolina good old boy lawyer. And his attorneys, who are also good old boy South Carolina lawyers, had filed a motion to dismiss his charges, or in the alternative, to get a new trial, because they believed that there was jury tampering that happened as a result of the court clerk, the elected court clerk, who may have made statements that could have influenced the jury. A very experienced senior judge was appointed to hear the post-trial motions on a new trial, and she was a former Supreme Court justice. She denied their motions and found that there was no substantial jury tampering. They have now filed a request. Typically what happens is a motion like that would go to the appeals court. The appeals court would make a decision, and then whatever the appeals court decided, they could appeal to the Supreme Court. The news is that the South Carolina Supreme Court has allowed them permission to jump over that intermediate appellate court step and to go to file their appeal directly with the South Carolina Supreme Court. Now, I don't know whether that's going to have any impact at all on the outcome. Who knows? But they have been able to jump that intermediate step. So I think I have run through all of the kind of pending cases that are out there. And I think we're ready to take some questions. We have about a half an hour, and I think that we're ready to have some questions. I want to, while Jen is queuing up questions, I want to thank everybody for being here. I know that your Wednesday night could be spent a lot of different ways, and I always appreciate it when you spend it with me. I do want to say that I am settled into my new house and feeling a lot more settled in general. My mom is settled into an assisted living very close to me. I'm super grateful that we were able to find a place for her that she is happy with nearby. So we are, things are calming down a little bit, and I am looking forward to getting more settled into our house. There are some really interesting color choices in a lot of places, like the Battleship Gray, that I'm going to be revising in the weeks to come. And I'm really excited. My daughter and her husband are going to come to visit and see the new house for the first time and look for a house for themselves over Labor Day weekend. So I'm excited that they're coming. We have met the neighbors in this amazing neighborhood. It is a little bit older neighborhood up on a hill where we have some really nice views of the Cascade Mountains, as well as the eastern view of the Red Rocks, Smith Rock, which is a rock climbing destination. And so other than the smoke from the wildfires, I think we're doing pretty well getting settled in. So yeah, I'm going to be doing a little painting and a little sort of adjusting. But other than that, we've met all the neighbors, and along our street, it is an amazing street of neighbors, well-established neighborhood with a lot of neighbors who've known one another a long time. And so it was really nice to be sort of pulled into the fold of this really great neighborhood. So what a phenomenal expense. Yeah, moving is always a phenomenal expense. And it's been a lot. And it's been 3 moves in 5 years, and I'm pretty done with it. So, I also wanted to say, the reason I got into that is that I'm finally going to be able to set my quilting station up again and be able to really dig into some quilting projects, including the crane quilt for Kay and Larry. So if you would still like to contribute a square, they are foundation piece squares. The background needs to be black. They need to finish at 6 1/4 inches to allow for seam allowance. And you are more than welcome to make more than one. The crane itself can be any color, bright colors, any pattern that you like. And I hope that you'll consider contributing. I have a new address, which I know that Jen has been putting in the comments and is in our show notes as well. That's the new P.O. box where you can send anything to me that you need to, including quilt squares. And when we get all of the quilt squares together, we will be I will be putting it together with some sashing, and we will be asking the ever talented Tracy Goyins to TERRI Goyins, sorry TERRI, to do the quilting for us. So ready to take questions if Jen, if you have some. We had so much to talk about. Is the prosecution hiding evidence in Kohberger? We're seeing a lot of that lately. You know, I think that we are seeing a lot more of what goes on a regular basis with defense attorneys pushing back against prosecutors. Here is what I think is the issue, and this is not a new issue. It is an issue that I faced when I worked as a defense attorney. Prosecutors have unlimited power and nearly unlimited resources, and they have the evidence. And defense attorneys don't know what they don't know. So sometimes it's easy for prosecutors to either purposefully or inadvertently or sloppily not provide evidence. And it's only when defense attorneys are able to connect the dots and dig into a case that they realize that they're missing things. For example, in the Daybell case, it wasn't until the defense attorney started digging into the fact that they had FBI reports of interviews that they were able to call out the prosecution and say, hang on, we don't have the recordings of those interviews. And reports are only summaries of what happens in an interview. So if you cannot actually watch the recorded interview, you don't have any way of knowing what the person's body language was, or whether the person who was actually conducting the interview and wrote the report felt that some of the evidence was, or some of the information that that witness said was irrelevant or unrelated. And prosecutors and law enforcement don't get to make that decision. Defense attorneys have a right to see everything, and defense attorneys decide what's relevant and what's not, what might lead to exculpatory information, what might lead to other information. So I think sometimes prosecutors, and this happened in Vallow and Daybell, take the position that if we're not going to offer it at trial, we don't have to give it to you. And that is not the legal standard by any means. I do think that this prosecution has been very, I will say that they have interpreted their obligation under Brady very, very narrowly, and in ways that I think are not appropriate. Now, do I know that they're purposefully hiding evidence? I don't know that. But it is extremely suspicious. In the Kohberger case, the probable cause affidavit outlined information that was provided to them by the FBI's CAS team. This is people who analyze cell phone location data, that analyze cell phone trap data. And the probable cause affidavit that was filed for the arrest warrant for Brian Kohberger was based on information that they had developed and received from the FBI. And yet, the prosecution says, we don't have that information. We got it from, we got verbal information from the FBI, but we don't have the reports. We don't have and they have tussled back and forth over this. And I think it's ludicrous that they have not gone out of their way to go and get those reports. Now, we saw in the Vallow Daybell case that the prosecution did go out of their way to get those reports, and they were provided to the defense. So we know, and this is in the same state. So this is the same state dealing with the same regional FBI office. It makes no sense. It doesn't make any logical sense that the FBI would readily provide that information to the Vallow Daybell teams, but not provide it in Kohberger. So something stinks there. And we are seeing a lot of that lately. My impression of, I think his name is Hellis, the prosecutor who is the elected prosecutor in Moscow, who is, of course, because he's in front of the cameras, prosecuting the case. And my impression of him is that he is arrogant, he is dismissive, he's a little misogynistic, he sort of, does the "go away girl, you bother me" with Ann Taylor, which I think is very inappropriate. And so I think there's a possibility that he is, at a minimum, slow walking and very narrowly interpreting his obligations under Brady. And I think it's going to come back to bite him, because I don't think Ann Taylor's going to let it go. She certainly does not impress me as the kind of lawyer who is going to back off. So everything I have seen about Ann Taylor impresses me, and I am going to look forward to seeing her defend a case, because I think if that case goes to trial, which I expect, first of all, she has repeatedly said that she and her team absolutely believe in Kohberger's innocence. This is not a case where the defense attorneys are going to be phoning it in. We are not going to see an Archibald Thomas defense the way we did in Lori Vallow's case. This is going to be a very full-throated defense. So I think you are going to see an eminently qualified and experienced and prepared defense attorney, public defender. I think that is a case to watch if you like trial and you like seeing how things happen in a courtroom. I'm excited for that one. Not because I'm excited that the crime happened. It's a horrendous crime, and I feel very sad for the families of the victims. But I am excited from a trial watcher and a trial participant standpoint. So, good question. Hi, I don't recall. You sound like Mr. Copeland from YSL. Every answer to every question was, I don't recall. Is the defense allowed to access to grand jury transcripts? They absolutely are. Grand jury transcripts are provided to the defense. They cannot be publicized. They can't be used. But the defendant is entitled to review those with their counsel, and they are to be reviewed by the defense. One of the things that at one point held up the Vallow and Daybell case was the fact that they had to wait for grand jury transcripts. And it's important to remember that the grand jury is a procedural step, but it's a very important procedural step. It is one of those very important safeguards in our system against wrongful prosecution. So it's very important that there is this review process to determine whether or not there is probable cause to bind the defendant over for trial. And that happens either at the grand jury or in a preliminary hearing, like we're going to see on Richens in Utah. And the only way that the defense has typically, although the defense attorneys can be present at a grand jury if they have already been appointed or retained prior to grand jury, they can be present, but they have no role in a grand jury. So they can be there as an observer, but they have no role. They can't question, they can't cross-examine. This is strictly presented by the prosecution. Once the grand jury then comes down with a true bill and an indictment is issued, the defense is entitled to have that transcript so that they can assure that that process happened appropriately and fairly and file any challenges to the grand jury process. There were challenges filed in Vallow-Daybell, but they were all sealed because they were grand jury proceedings. So we don't really know what the challenges were, whether it was to the makeup of the grand jury, whether there were concerns about there being bias in the grand jury, or whether there were concerns about there being some sort of conflict of interest in the grand jury. The judge denied all those motions very early on, and we went forward all the way to trial. So, but grand jury transcripts, it's a critical step that they be reviewed by the defense. Good question. Of course, you guys always ask good questions. Okay, what else do you have for me? Oh, Jen is sending me a message, so there must be something going on here. Why am I not? Hang on, Jen. I'm getting there. No. Are you able to? Jen, you might. Okay, I gotcha. Yeah. Briefly. So, any other, y'all think, if you've got any other questions having to do with the cases that we've talked about, and I will answer this one. Hi, Kathy White. I know that there is a lot of chatter going on. Now, y'all know me, and y'all know that I don't speak ill of anybody on this channel. I understand that my position that I took in my surprise live having to do with the Daybell property may not be everyone's opinion, and we are all entitled to our opinions. And what I love about our community is that we all manage to stay civil and kind when it comes to differences of opinion. So I happen to know the people, I met them through the Daybell trial. I happen to know the people who have purchased Chad Daybell's property. Now, for those of you who may not have seen the surprise live or heard any of the chatter, John Pryor put the Daybell property on the market. At that time, Emma Daybell and her family were still living in the property. And I'm going to make this really brief because I'm not going to belabor it. But this person had talked to her family about, wouldn't it be great if that property could be used in some constructive way for the community, not just the family, but the entire Rexburg, Fremont County, Madison County community that has been so deeply affected by the cases. And so she decided, I'm going to go out and take a look at the property just because I want to understand the property and maybe get a sense for what it could be used for. While she was there, the person who was showing her the property she overheard a conversation. The person was talking openly on their cell phone about the fact that the other interested party was a group who intended to buy the property and turn it into a macabre novelty murder Airbnb. And she was horrified and outraged and went back to her family and decided that they would immediately make a full price, $350,000 offer on the property so that it would not end up being used for that use. The timing was not great because it was summertime. They had an annual vacation plan to go fishing in Alaska, in a remote area in Alaska. So the transaction was underway. They had decided that they're going to set up a nonprofit corporation, that they were going to have the corporation purchase the property. That would allow them to do fundraising to support any kind of activities and renovation of the property. And that they were working on all of that. In the meantime, they went to Alaska for 2 weeks. The plan was that they were going to come back from that Alaska trip and they were going to meet with their business attorney. They were going to finalize the formation of the nonprofit corporation. And they were working with people who were people from the area who were offering in-kind services, and they were trying to figure out how to work that into the project. And they were still really in these very preliminary stages because they haven't had much time to plan. So unfortunately, because Rexburg is a very small, tight-knit community, someone at the title company leaked their identity, which they really didn't intend. And they were suddenly in this remote place in Alaska, getting inundated with their phone blowing up. So to head that off, they issued a press release, which we talked about on our live last week. And it really just gave some very basic information about what their intentions are. Their intentions are to create a community space. The dwelling that is on the property, Chad and Tammy's home, is essentially a tear down. And so it's their intention to take down all the buildings that are on the property and to turn it into a community space that will include a memorial for JJ, Tammy, and Tylee, as well as a community space for healing. The specifics of that plan have not been made, which is why they had not yet reached out to any of the victim family members, because they didn't have a plan. All they had was the bare skeleton of some brainstorming and an offer to buy the property. Once the news release went out, the families were unhappy. Kay and Larry Woodcock have expressed that they're unhappy. And I said, and I stand behind this, Kay and Larry's opinion, while the owners of the property should be taking their opinion into consideration, they do not get a vote because they are not going to be the property owners. Now, I know these people, and I know that they genuinely, and they have reached out to Kay and Larry, they genuinely want to respect the wishes of the victims' families. And they genuinely want this to be a place for healing for the entire community. It's a bigger project than just healing for the families of the victims. It is as much that as it is a project to facilitate the healing of the community. I have no direct input. I have no direct involvement. I am in no way advising them. They simply shared the information with me. I don't have a dog in the fight. I hope that they will continue to consult the members of the family, but ultimately they will be the owners of the property, and they will be entitled to make decisions about the use of the property. They have been incredibly sensitive and respectful about what they intend to do. So something I said on that live was pulled out as a pulled clip and has been circulating on the internet. Those of you who know me know that I am not going to call out other creators. I don't do that. But I am going to allow karma to catch up with the people who are trying to take a good thing and make it a bad thing. It is not, it's not helpful, constructive, and this particular creator has history with me and has gone out of their way to create problems behind the scenes in my life. I don't call people out, and I don't make public those things because that's not what we're about here. We're about talking about the law, how the law applies to these cases, and we're about lifting people up and moving people forward. So I'm not going there. You all can draw your own conclusions from what I have said and what other people are saying. And you can draw your own conclusions, and I will respect those. For those of you who found what I said objectionable, I'm sorry, but it doesn't change my opinion. And I delight in the fact that we have put together a community that can disagree and still come together and be supportive of one another and respect one another. So that is all I am about to say about the Daybell property. I don't have any other involvement in it other than I appreciate what these people are doing for the Madison and Fremont County community. And what they're trying to do is much bigger than some very small-minded people. So thanks for all of the very nice messages of support that I've gotten from all of you this week. I do appreciate it. Hi, Christina Jones. I noticed some of Chad Daybell's books are still available on Amazon in new format by his publishing company, Spring Creek Book Company. Do you know if Chad Daybell still profits from this? Here's what I know. This is a really good question. And I want to be, I'll tell you what I know at this point. When Chad and Tammy declared bankruptcy, they turned over their physical stock, their copies of Chad's books. Although there were some found in the house, by the way. they turned over their stock to a distribution company. That was part of the bankruptcy process. Was the bankruptcy trustee became in charge of that, and those books were essentially sold to a distribution company. So that whether or not they got any benefit from it was tied up in the bankruptcy that happened quite a few years before all of this happened. So whatever benefit they might have gotten out of it, they were kind of liquidated as part of that bankruptcy, and they were sold to this distribution company. So the distribution company now fulfills the Amazon orders. That is why when a lot of people went back to Amazon and said, you need to take these books down, Amazon said, we can't take them down because our deal is with this distribution company, and they don't have anything to do with Chad Daybell or with what happens. So under the Idaho Slayer statute, he could profit from these books if it were possible, because they are not about his crime. But I don't believe that he has any right, any monetary interest in those books, because they were all sold off to the distribution company. So it's kind of a convoluted thing. It's possible early on in the bankruptcy, there may have been some benefit that offset the bankruptcy with the value of the books. But I guarantee you he is not seeing any profits through any of the Amazon sales. So rest assured at this point, if there is any profit to be had, it's going to that third-party distribution company. Well, we are at the 2-hour mark. Let's make sure we don't have any other significant questions. So, we'll take a couple more, and then we'll say goodnight. Hi, John Schaefer. Do the actions taken by Sarah Boone in regards the jail set precedent for future pro se defendants? Yeah, I think so. I don't think that what the jail has agreed to for her is all that unusual or out of the realm of possibility. She may very well be the first pro se defendant of this kind of a complex case, since everything really went purely electronic. And that's really kind of throws a wrench into things. But typically, the jail is going to the extent that they can and still observe security concerns, they're going to make things available to her, because the jail does not want to be the ones responsible for there being any kind of a Sixth Amendment violation to her right to counsel, because she still has a right to counsel, even if it's that she's her own pro se counsel. And that means that she has a right to prepare her case. And preparing her case means she needs access to case files, to the discovery information. She needs access to an investigator who can work on the outside, making phone calls, doing investigation, interviewing people, those sorts of things, looking at the evidence. So the court has approved her, the expense of her investigator. The jail has made the investigator available to her very readily. There's still sort of the issue of she's limited on phone calls. She can make phone calls to her investigator, but she's limited with that 15-minute time limit. So I can see that it's not easy. It's a frustrating situation because she's having to sort of learn on the fly. The Florida Defense Organization has given her a packet of information for pro se litigants, including sample forms and a lot of information. So they're trying to do what they can to stave off some sort of appeal based on a violation of her Sixth Amendment rights. I am certain that if she is convicted, there's going to be appeal after appeal having to do with the violation of her Sixth Amendment rights. But whether or not that flies, sort of like ineffective assistance of counsel, you still have to prove the outcome would have been different. So good question. Yeah, I do think that in the future, the jail will be expected to make similar accommodations. But remember, they declined to make a lot of accommodations she asked for. They didn't give her access to the internet. They didn't give her headphones so she could listen to privately to stuff on the computer, recordings. They didn't give her the right to keep the USB drives in her own possession. They didn't give her the right to use a separate workspace classroom for preparation. So they denied a lot of those of her requests. So good questions tonight, everybody. We zoomed through a lot. I am going to continue to keep up on those cases that are live right now, and we'll be talking at length about those. I definitely want you to, if you're watching, keep track of your questions, because I'm going to keep up on Young Thug and see where that goes, because I think there are still going to be motions for mistrial in that case. I am going to keep up on Robert Hellis, that's the investigative reporter murder. I am going to keep up both on Susan Lorenz, the murder of the single mom over kids playing in the vacant lot, and as well as Crystal Rogers. So I will do my best to keep up on those as we go along. And if questions come up as you're watching them, jot them down and we can talk about them next Wednesday. I want to thank everybody for being here. I want to thank everybody who has been incredibly supportive of my channel. I want to thank everybody who has pre-ordered the book. I will be getting news out about book signings as we get those set up. And I want to thank everybody the folks who have signed up to get the PDF and review it ahead of time. I am, now that life has settled down a little bit, going to be doing a few exclusive kinds of things for folks who have signed up to be on the book launch team. And so look for those now that I can actually find things in my house. So as always, I want to thank Jen for being moderator par excellence, and I appreciate all of you, and I appreciate her. So please tune in next week on Wednesday. If there are any big developments that happen between now and then, look for Surprise Live. So it's always a good idea to subscribe and hit that notification bell. I'm going to say good night, and we'll see you next week. Good night.